Very good evening, everybody. Quick audio check. Am I audible and visible to everyone? Before we start, let's just do the regular routine audio video check. Am I audible to everybody? Am I visible to everybody? Okay. Good evening, Sindhuja. Thank you so much for letting me know, bhai, that we are audible, that I'm audible as well as visible. Chalo, good. Good to know. I see a lot of you are here today for this last session that we're doing on procedural laws. Okay. Now, for those of you who are new to this session, who are attending for the first time, or if you are, viewing this video on a later date, just a brief, catch up for all of you. We are doing this session on miscellaneous laws. So we've had a lot of sessions, close to 10 odd sessions, I think, by now on the topic of miscellaneous laws. We've covered various aspects of various concepts which come under this umbrella of miscellaneous laws, because CLAT में आप topic wise तो हम कर लेते हैं criminal, contract, constitution, torts, but then फिर एक वो umbrella सा एक आ जाता है जिसमें miscellaneous laws का एक बहुत बड़ा सा bundle होता है, and that generally tends to confuse us, right? That is the reason why we came up with this concept of tackling this entire umbrella of this bundle of topics which is covered under miscellaneous laws. So this, what we are going to do today is in continuation with procedural laws. So हमने पहले काफी कुछ करा है miscellaneous laws में. We've done in environmental law, that's what we began with, and then we did family law, and now we are on procedural law. Okay, तो अब हमने जब procedural law करा है, we've already done CRPC, that's your criminal procedure code. We did CPC in the last session. And today what we're going to do is the Indian Evidence Act. These are three main procedural laws so far as our country is concerned, right? And directly आपके पास procedural law के questions, you might feel कि ये तो बहुत difficult topics होते हैं, but इसमें से you will realize, and through the course of today's session also, like always I keep telling you कि भाई कैसे ये आपके CLAT में आ चुका है, कैसे ये concepts आपके exam में आते हैं. That is the reason why we are having this session. And we are not going to study the Indian Evidence Act. Okay, mind you, the session is on evidentiary law, but we are not really going to go into the provisions ki section ye kya bolta hai, section wo kya bolta hai. Don't worry on that front. Okay, it's not going to be a session aap judiciary ki tayari nahi kar rahe ho. There's a difference between a 70 and 18-year-old preparing for CLAT undergrad and somebody who's preparing for CLAT PG or maybe preparing for judiciary. That's a separate ball game altogether. That is why a session like this I feel is essential, so that you guys don't start going too much in detail, which is not needed, but a certain basic understanding of law is what is important. Okay, Ayush is asking me, ma'am, is this topic important for CLAT? Let me see. There are certain topics on evidentiary law which have appeared in your exam. In fact, if I remember correctly, AILET का 2021 का पेपर था जिसमें एक direct concept आया था on evidentiary law. अभी जैसे जैसे हम सेशन करते जाएंगे, I will highlight that to you as to कहाँ पे हमने how in what form it has come in your exam. ठीक है, तो important है, एक general understanding के लिए important है, right? Not कि आपका बहुत ही specific topic wise question आएगा, but yes, generally there are passages or there are questions which are framed around the Indian Evidence Act. ठीक है, चलो अब start करते हैं. Let's begin. Good evening. Okay, let me see who all have joined. I have Sindhuja, Ayush, Hasika, Supriya, Chahat. Good evening to all of you. And let's begin, right? So, those of you who've been with me in this session, bhai ye cheez to hum already samajh chuke hain. So everybody knows what substantive law is, and I'm hoping everybody knows what procedural law is also. But just a quick overview. Substantive law is the law which gives you rights, right? So any kind of law which gives you rights is what is a substantive law. How do you go ahead and implement these rights is going to be your procedural law. So it provides you the process कि भाई implementation आपका कैसे होगा in laws का. That is what is known as procedural law or adjective law. ठीक है, तो ये एक बेसिक अंडरस्टैंडिंग थी. यहाँ पे एग्जांपल्स लिखे हुए हैं. व्हेन यू टॉक ऑफ क्रिमिनल लॉ, आईपीसी इज योर मेजर सब्सटैंटिव लॉ. सिविल लॉ इज वाइड. इंडियन कॉन्ट्रैक्ट एक्ट आप पढ़ते हो, हिंदू मैरिज एक्ट आपने पढ़ा है, ऑल दोज आर civil laws. Similarly, procedural laws, like I just mentioned, we've done CRPC, we've done CPC, we've touched upon limitation as well. Today what we're going to do is your evidence, law of evidence. In fact, कई बार कई लोग बोलते हैं कि भाई जो evidentiary law है, some people even try to create a third facet of law. They say that substantive law is one, procedural law is your CRPC and CPC, and they don't like to club evidentiary law within it. They say कि भाई evidentiary law एक third कैटेगरी है जिसको हम completely separate treat करेंगे. That sometimes you want to refer it to as adjective law also, but वो सब सिर्फ theory होता है, उससे आपको इतना लेना देना नहीं है. Right now, so far as you guys are concerned, the three major laws जिसके ऊपर आपके questions ज़्यादातर आते हैं, they are your CRPC, your CPC, and Indian Evidence Act, right? These are supposed to be the three major pillars when it comes down to the process of a trial, right? The process of a criminal or a civil trial. Now, I'll just broadly give you an understanding how evidence law comes into play when we talk about this, right? Let's take the example of a criminal case. A crime सबसे पहले commit होता है, right? So first of all, what we have is an offense. तो एक offense हुआ. Offense की उसके बाद क्या होगी? Reporting, right? You can file a report either with the, how do you report an offense? If there is an offense which has been committed, how do you report it? Can anybody tell me? This is a very general question. अब तो बहुत बार कर भी चुके हैं इसको. So I'm hoping that those of you who've been here with me are aware of this. Good, Supriya, you can file an FIR. Any other way of reporting it? Is FIR the only way? First information report, that means we're going to the police. Reporting एक तो पुलिस के पास हो जाती है, and to the magistrate also. Good, Supriya, good, Chahat. You can file, this depends, CRPC में provide करा है कि भाई कुछ ऐसे offenses होते हैं जिनमें आप पुलिस के पास जाते हो, certain offenses which are known as complaint offenses जिसके पास आप magistrate के पास जाते हो. तो offense हुआ, आपने report कर दी. Report करने के बाद क्या होगा? Investigation, right? The investigation happens. After investigation comes the phase of cognizance. Now, cognizance का क्या मतलब होता है? यहाँ पे हम बात कर रहे हैं the time when there is a hearing of charge which happens and charges get framed, right? तो जहाँ ये charges frame हो गए हैं, इसके बाद आपका शुरू होता है trial. So tell me, ये offense report investigation, does CRPC have a role to play in this? Yes or no? Will the CRPC, the Criminal Procedure Code, does it have a role to play in this? कि भाई offense है, report है, investigation पुलिस को करना पड़ेगा, then there will be hearing of charge, cognizance आपने लिया, and then the trial begins. Does the CRPC have a role to play? Yes, of course it has a role to play, right? Because that is the one which is telling you कि भाई आप report file करोगे. It is telling the investigation agency कि भाई आप investigation करो, and फिर magistrate के पास जा रहा है cognizance के लिए, right? So okay, so I believe all of you are, till now you are with me. Now tell me, अब यहाँ पे would the Indian Evidence Act also come into play? Indian Evidence Act क्या provide करती है? दोनों के लिए. Okay, Indian Evidence Act is common. It is common for CPC and it is common for CRPC, right? So you have one Evidence Act. You do not have two separate laws on evidence कि भाई civil law के लिए अलग evidentiary law होगा और criminal law के लिए अलग नहीं. एक ही evidence law है हमारा Indian Evidence Act, which tells you the kind of evidence that you can bring in a केस। ठीक, तो मुझे बताओ जब ये ऑफेंस, रिपोर्ट, इन्वेस्टिगेशन, कॉग्निजेंस हो रहा है, यहाँ पे वुड द इंडियन एविडेंस एक्ट कम इन टू प्ले? यस और नो? प्रोसीजरल लॉ तो आएगा आपका, बट would the Indian Evidence Act come to play here? The answer is no. Okay, I believe Supriya is saying चाहत, and I think some of you feeling कि भाई क्यों नहीं आएगा? Important चीज आपको इंडियन एविडेंस एक्ट के बारे में हमेशा समझनी है, that Indian Evidence Act tells you that during judicial proceeding, कि भाई जब आपकी जुडिशियल प्रोसीडिंग चल रही है उस समय what can be brought as evidence and what cannot be brought as evidence, because evidence basically क्या होता है? Proof, right? You are trying to prove something. So when you are talking about evidence, this is something which comes into play when you're talking about a judicial proceeding, right? Here जब आप offense की बात कर रहे हो, रिपोर्टिंग की बात कर रहे हो, इन्वेस्टिगेशन एंड कॉग्निजेंस की, till now basically what is happening is merely a, it's sort of an administrative process, right? It's sort of this process, it's kind of administrative in nature. And also अगर आपको लग रहा है कि नहीं, but इसमें तो एविडेंस कलेक्ट हो रहा है, रिपोर्ट जब इन्वेस्टिगेशन कर रही है तो पुलिस तो एविडेंस कलेक्ट कर रही है, यू आर राइट, you are collecting evidence, right? Here पुलिस जो है वो क्या कर रही है? ड्यूरिंग इन्वेस्टिगेशन दे आर कलेक्टिंग एविडेंस, राइट? बट द जुडिशियल प्रोसीडिंग हैजंट टेकन प्लेस एज येट, राइट? सो व्हेन यू आर लुकिंग एट द इंडियन एविडेंस एक्ट, ऑलवेज रिमेंबर इंडियन एविडेंस एक्ट क्या बात करती है? इंडियन एक्ट बात करती है कि भाई ये जो ट्रायल जब चलेगा उस टाइम पे क्या चीज आप एज एविडेंस you can bring it to the court, what you cannot bring to the court, because something which the court says fine, admitted, ये evidence है, then वो आपको याद होगा, everybody remembers that इंसान इंसाफ की देवी, that हम हर हिंदी पिक्चर में आजकल थोड़ी कम हो गई, पहले तो हमेशा होता था वो काली पट्टी बांध के तराजू पकड़ के, there is that इंसाफ की देवी, everybody remembers that इंसाफ की देवी, yes? अब वो इंसाफ की देवी जो होती है, उसकी आंख में जो काली पट्टी बंधी हुई है, उसके जो वो दो स्केल्स है ना, दो तराजू के जो दो स्केल्स होते हैं, दो स्केल्स व्हाट डू दे कंटेन? दे कंटेन एविडेंस व्हिच इज एडमिसिबल। एक बार आपने एडमिसिबल, कोर्ट ने डिसाइड कर लिया कि हाँ भाई ये एडमिट करने लायक है, इसको आप एज एविडेंस यू कैन टेक इट इन, तो फिर आपके तराजू में वो डाल दिया जाएगा, एंड देन देन जस्टिस इज ब्लाइंड, देन फिर जस्टिस जो है आंख बंद करके देखेगा कि भाई किसका तराजू एडमिसिबल एविडेंस की तरफ से भारी है, एंड उसकी तरफ आपका जजमेंट जाएगा, राइट? सो ऑलवेज रिमेंबर व्हेनेवर यू आर टॉकिंग अबाउट एविडेंस और इंडियन एविडेंस एक्ट, here we are talking about admissibility or we are talking about evidence जो कि judicial proceeding, trial के टाइम पे क्या चीज आप कोर्ट में एज एविडेंस दे सकते हो, क्या चीज आप एज एविडेंस नहीं दे सकते हो, दैट इज व्हाट द इंडियन एविडेंस एक्ट इज बेसिकली अबाउट, राइट? अ वेरी बेसिक थिंग, बट over the last 3-4 years, जब से क्लैट का पैटर्न चेंज हुआ है, what you realize is, and I think you must have realized, all of you have been solving the PYQs, past year questions, कि बहुत ये बेसिक कॉन्सेप्ट्स अगर समझ में आते हैं तो फिर आपको मिसलेनियस वाले प्रॉब्लम्स, पैसेजेस या रेगुलर पैसेजेस भी सॉल्व करने में प्रॉब्लम नहीं होती, राइट? सो दैट इज व्हाई ये एक कुछ बेसिक कॉन्सेप्ट है जो क्लियर होना चाहिए, ठीक? Supriya, bacha, we are just beginning, right? Don't worry, we will talk about the kind of evidences. In fact, Ayush ने भी पूछा है, भाई मैम दो टाइप के एविडेंस होते हैं, some there, some not there, primary, secondary. भाई ये बहुत हवा वाली बातें हैं, हम we will deal with them in detail, don't worry, right? That's what the class is about, just because these are words which are thrown everywhere and they're used very recklessly, I feel, most of the times, right? So let's just get to the बोलते हैं ना कि क्या बोलते हैं, let's get to the root of the matter and just try to understand that what exactly do they really mean. Okay, यहाँ तक ठीक है. So now we know that so far as Indian Evidence Act is concerned, it is basically dealing with judicial proceedings. And उससे पहले वाला जो काम है वो पूरा administrative type काम है, which is not going to be is not going to be of concern so far as the Indian Evidence Act is concerned. Right, now let's move on. Now what is the law which governs evidence in India? You have the Indian Evidence Act. बहुत पुराना law है ये. This is 1872 का act है ये. And उससे पहले we had Evidence Act, but then it wasn't really very clear and consolidated. So it was consolidated, defined, amended. This is the object. जो object clause होता है ना एक एक्ट का सबसे ऊपर जो फर्स्ट लाइन होती है, दिस इज आल्सो नोन एज द लॉन्ग टाइटल. शॉर्ट टाइटल होता है इंडियन एविडेंस एक्ट और लॉन्ग टाइटल ये है एन एक्ट टू कंसोलिडेट, डिफाइन, अमेंड लॉ ऑफ एविडेंस. इंपॉर्टेंट चीज, सिविल क्रिमिनल दोनों में अप्लाई करेगा. एंड समथिंग विच इज अ प्री रिक्विजिट, बिना एविडेंशियरी लॉ के आपका प्रोसीजरल लॉ जो है वो और आपका सब्सटैंटिव लॉ है, इट विल नॉट रियली बी ऑफ एनी यूज. दैट हाउ डू यू रियली प्रूव अ केस इज समथिंग विच इज वेरी वेरी important, right? So that is something which is important. What is the role of evidence? It says to scientifically reconstruct past events on which disputing parties disagree. Because end of the day, evidence क्या करता है? Evidence करता है कि भाई जो कहानियां लोग सुना रहे हैं, there are two parties and they are not agreeing with each other. They are disputing. Right, so when they are disputing, so you try to reconstruct कि भाई past में हुआ क्या था. You try to look for the truth. You try to seek the truth, and whatever is the truth which comes out of all the evidence which has been brought about, that is what the entire purpose of evidence law is. End of the day, जब आप कोर्ट जाते हो किसी भी मैटर के लिए, what the result is all dependent on the evidence that you are able to bring. ठीक, अच्छा ये हमने अभी अभी किया. जुडिशियल प्रोसीडिंग है, नॉट इन एडमिनिस्ट्रेटिव प्रोसीडिंग में काम नहीं होता है so far as evidence is concerned. Okay, very very basic things, nothing to worry about here. Now let's understand the historically, what does the word evidence mean? Okay, so quickly tell me, what do you understand by evidence? Bhai main isko piche kar deti hu. Tell me, what do you mean by evidence? Let me guess. Let me get it from you guys. Yes, quickly tell me, what does the word evidence mean to you? According to you guys, what does the term evidence mean? होता क्या है एविडेंस? बहुत ही often used, misused, as proof. Okay, proof, evidence as proof. Yes, that's the simplest way of putting what evidence is, कि भाई ये proof है. Right, okay. So anybody else has any other definition? I'm getting proof. Validation of a statement or an event by proof. Okay, so you're saying validate करना कि भाई अगर आपने ये बोला है कि A ने B का मर्डर करा है, तो भाई A ने B का मर्डर करा है, how do you validate your statement? That is going to be evidence. Okay, good. So that is exactly when we are looking at the history of the word evidence. It comes from a word, Latin word called evidere. और इसका क्या मतलब होता है? Clarity in presentation, or the ability to prove the facts in question. So whatever are the facts, whether you are able to substantiate those facts, whether you are able to prove कि भाई जो आप quote कर रहे हो क्या वो सही है, क्या वो गलत है, that is exactly what evidence is, right? So when you are talking of evidence, it could be, it tries to confirm or refute the truth or falsity of a fact, right? So it's basically confirming or refuting कि भाई ये सही है या गलत है of a fact. If you look at the concept of evidence, you always realize कि ये हमेशा fact और fact के ऊपर ही revolve करता है. Whether it's talking about confirming or refuting the truth or the fallacy. In fact, when you guys are saying proof कि भाई evidence proof होता है, किस चीज का proof होता है? Proof of a certain fact, right? So इट कुड बी द पार्टी हु क्लेम्स, उसको प्रूव करना पड़ेगा कि भाई एग्जिस्टेंस है, या जो डिस्प्रूव करती है उसको प्रूव करना पड़ेगा कि ये एग्जिस्ट नहीं करता है. लाइक इफ A is saying that he murdered B, then he will have to prove the existence of the fact that A was murdered by B. राइट. ऑन द अदर हैंड बी को डिस्प्रूव करना पड़ेगा कि भाई बी ने मर्डर, ए ने बी का मर्डर नहीं किया, समथिंग लाइक दैट. देयर हैज टू बी अ प्रूवल एंड डिस्प्रूवल. Important takeaway from this is that evidence law as such is always revolving around the concept of fact. तो जब हम fact देखते हैं, जब हम law of evidence देखते हैं, what is really important is that what is this fact for which you can bring evidence? Because when you are looking at a case, there will be a lot of facts which are involved. Can you bring evidence for each and every fact that is surrounding? No, you can bring evidence only for certain facts. ऐसे facts जो कि essential है उस particular case में. So law says that you can bring in evidence only if you fall in any of these two categories of fact. या फिर वो fact in issue होगा, which is also known as factum probandum, which basically means कि आपका जो main issue है, आपका जो main point है, main principle जो point है, जो आपको prove करना है उस case में, वो क्या होता है आपका fact in issue. Like let's say for example we are saying that A murdered B. तो यहाँ पे fact in issue क्या होगा कि भाई A ने B का murder करा है. So the first fact in issue would be that A has murdered B. So that's your first fact in issue. Can there be any other fact in issue here? Can anybody think कि भाई fact in issue क्या होगा? Main fact क्या होगा यहाँ पे कि भाई A ने B का murder करा है? Yes, that's one. और क्या हो सकता है? अब आप लोगों ने सबने murder पढ़ा हुआ है, right? Everybody knows what a crime is. Crime में क्या दो important aspects होते हैं? अगर वो दोनों हुए तभी क्राइम होगा, अगर दोनों में से एक भी मिसिंग है तो क्राइम नहीं होगा. Can anybody tell me the two important aspects of a crime? Mens rea and actus reus, right? So there has to be mens rea and there has to be actus reus. तो अगर आपका this is what you want to prove that A murdered B, तो fact in issue होगा, okay, somebody has told me कि भाई shooting करके murder हुई है, सार्थक बोल रहा है कि A shot B. So this would be a first fact in issue that A shot B. Second fact in issue क्या होगा कि आपको mental element prove करना पड़ेगा. तो mental element prove करोगे तो वो क्या होगा कि भी A intended to shoot B. That means जब आप फैक्ट इन इशू की बात कर रहे हो तो जो आपका मेन क्वेश्चन है, जो आपने कोर्ट में जाके प्रूव करना है, वहां पे दोनों चीजें होंगी. इट विल इंक्लूड द एक्चुअल फैक्ट, द फिजिकल एस्पेक्ट ऑफ दैट फैक्ट एज वेल एज द मेंटल एस्पेक्ट. तो फैक्ट इन इशू आपका दोनों होता है, फिजिकल भी हो सकता है एंड मेंटल भी हो सकता है. Being a criminal offense, mental aspect उतना ही essential है जितना physical, right? Both of them are equally essential because without mens rea or without actus reus, there cannot be a crime, right? So when you are talking about fact in issue is the main point, the principal thing जो कि आप कोर्ट में prove करने जा रहे हो. That is going to be a fact in issue. तो अगर आपने आपके घर में चोरी हुई है तो चोरी के में the fact that A did steal your watch, then that is going to be a fact in issue. And B would be that A actually intended to steal your watch, the mental element, that would also be your fact in issue, right? So both the things together will have to be proved if you want your case to succeed. तो ये आपका directly आप केस से चाहते क्या हो. So fact in issue is basically directly what is it that you are wanting from the case. बहुत बेसिक तरीका समझने का ये होता है फैक्ट इन इशू का. तो एनी काइंड ऑफ एविडेंस विच इज हेल्पिंग यू प्रूव फैक्ट इन इशू, तो वो आपका एविडेंशियरी वैल्यू होगा उसका. सो इफ मान लो ए ने बी का मर्डर करा है एंड मिस्टर एक्स ने देखा है, राइट? मिस्टर एक्स सॉ दैट ए वाज मर्डरिंग बी, सो दिस बिकम्स योर फैक्ट इन issue because he is an eyewitness. ये eyewitness है and he has directly seen that A has actually shot B. So here this becomes a fact in issue, or this, for proving this fact in issue, this becomes a direct evidence, right? So this can be brought in as evidence. तो ये क्या हो जाएगा आपका admissible as एविडेंस. तो ये जो हमारी इंसान की इंसाफ की देवी की जो तराजू में हमने डाला था एडमिसिबल एविडेंस, ये एक वहां पे एडमिसिबल एविडेंस आपका +1 हो गया, राइट? सो दिस इज व्हाट इज मेंट बाय फैक्ट इन इशू. तो एनीथिंग विच इज हेल्पिंग यू प्रूव योर फैक्ट इन इशू, दैट विल बी कंसिडर्ड एज एडमिसिबल. दूसरा आता है व्हेन यू टॉकिंग अबाउट रेलेवेंट फैक्ट. रेलेवेंट फैक्ट ऐसा फैक्ट है जो कि आपको फैक्ट इन इशू को प्रूव करने में हेल्प कर रहा है. So here, this is the direct main point जिसको आपको prove करना है. Relevant fact is fact which helps in proving your fact in issue. It's something like, you know that A shot B. अब आपको intention भी prove करना कि भाई A intended to shoot B. अब आपने देखा था that, you know, let's say for the past 2 odd weeks, A and B had been, you know, having very vicious fights. So, यहाँ पे the prosecution will bring evidence that A and B, you know, on some point or the other, they had been having these regular, very strong arguments. तो ये जो A and B के बीच में ये जो continuous arguments हो रही थी, heated arguments जो हो रही थी यहाँ पे, would this help in proving intention? Would this in some way help in proving the intention? कि भाई इसका A का इंटेंशन हो सकता है B का, बिकॉज इनकी कुछ दिनों से आपस में वैसे ही झड़प चल रही थी. Now this is what is a relevant fact. Now this is not something which is an issue directly. क्वेश्चन ये नहीं है कि उनकी हीटेड आर्ग्यूमेंट चल रही थी या नहीं, बट क्वेश्चन ये है कि भाई उसका इंटेंशन था मारने का या नहीं. Right? So when you look at relevant fact you will realize are very close to weak preparation आप किसी कर रहे हो, that would also become relevant fact. आपका क्या motive था, that would also become relevant fact. Right? So relevant fact is something which is helping you in proving the fact in issue. अगर आप इन दोनों में से किसी में भी fit हो जाते हो, then that kind of evidence is considered as admissible, and that is the evidence which you can bring before the court. Right? Now, you don't have to go into too much of nitty-gritty of this. Okay, I don't want you guys to, you know, start thinking, oh no, अब इसमें question में ये आ जाएगा कि fact in issue क्या है और relevant fact क्या है. इतना आपसे expected नहीं है CLAT में. In fact, you know, if you look at the Indian Evidence Act, relevant fact की बहुत लंबी चौड़ी definitions है. There are like about 10-12 sections which are talking about nothing but relevant facts. उसमें one of the sections says that, you know, anything which deals with preparation, anything which deals with motive, all that also become relevant facts. Right? तो इस type के provisions जो है वो आपके exam में आने के chance है. Right? So the reason why I'm introducing these concepts is so that you don't find them uncomfortable if they come. Right? So relevant fact is something which is helping you prove a fact in issue. तो जो आपको help करेंगे prove करने में वो relevant fact है, and उसको prove करने वाला evidence is also admissible. Direct fact in issue को जो prove करेगा, of course that is going to be admissible. ठीक? So both the kind of, these are the only types of facts which have evidentiary value. इसके अलावा जो facts होते हैं, generally कुछ exceptions हो सकते हैं, but generally apart from this, you don't really have facts which have evidentiary value, right? इसके अलावा, you know, I'll give you one exception to this rule would be when you talk of the character. वो भी kind of a relevant fact होता है, but kind of sometimes you feel कि is the character of a particular individual, of a particular accused. मान लो कि there is this person, same here, A has shot B and A intended to shoot B. हमारा ये murder trial चल रहा है. तो यहाँ पे हमें A का character prove करने के लिए there to a certain extent you can bring some witnesses, right? But you can bring only one or two witnesses which will help you gauge just the character of A so far as shooting B is concerned, not the character of A in general, कि भाई वो बहुत फ्लैम्बॉयंट नेचर का है या बहुत शाय नेचर का है या बहुत ग्रेगेरियस है, उस टाइप का नहीं. But yes, vis-a-vis this particular fact that he has actually shot B, could he be capable of killing anybody? And things like that, you could bring a character witness or two, right? So, इस type का, पर यहाँ पे भी आप you'll realize it is still has to be relevant, right? So, generally, fact and issue or relevant fact, अगर ये दोनों fact है, तभी evidentiary value होगा, otherwise not. Yes, Hasika, sometimes that can become a relevant fact, when you have these heinous crimes, or you might have at times, crimes related to fraud and things like that. So there could be a case wherein you could be allowed a character witness. Yes. सिर्फ पिक्चरों में नहीं होता है, रियलिटी में भी होता है, ठीक है? चलो, okay. So this is so far as facts is concerned, very very important, because evidence basically पूरा का पूरा law जो है fact के around revolve करता है. ठीक? चलो, I hope everybody is clear on this. Okay, let's move on. नेक्स्ट है टाइप ऑफ एविडेंस. अब ये कोई मेरे से ऊपर पूछ रहा था, अब हम इस पे आ गए हैं. सी, व्हेन यू आर टॉकिंग अबाउट टाइप्स ऑफ एविडेंस, द इंडियन एविडेंस एक्ट इटसेल्फ प्रोवाइड्स यू डिफरेंट टाइप्स ऑफ एविडेंस. अब कौन से टाइप का एविडेंस होता है, ये दो जो है evidence act very specifically provide karta hai. When they start talking about, they say there are two types of evidence. One would be oral evidence. Oral is obviously, when you are saying something. So oral ocular bhi bolte hain isko kai baar. It's the same. Oral evidence or ocular evidence is the same thing. Important kya hai? Oral evidence direct hona chahiye. It should not be hearsay. Which means that if I am giving evidence, if I am saying that I have seen A killing B, तो अब यहाँ पे अगर मैंने A को B को मारते हुए देखा है, only then my evidence would be admissible. So my oral evidence saying that yes, I saw A shooting B. So the fact that A has shot B, that is going to be my direct oral evidence. So that is going to be admissible. But I cannot say that I was told by my friend X that she had seen A shooting B. अब ये क्या हो जाएगा? Hearsay. Because I did not directly see that, but I heard it. So when you are saying oral evidence must be direct, always remember ये सिर्फ देखने, seeing से ही नहीं होता है, because one tends to keep thinking that oral evidence, that means I have seen it. No, it could even be that I heard it. तो वो ओरल डायरेक्ट एविडेंस हो जाएगा अगर मैंने हियर किया है. तो आई हर्ड ए प्लान बना रहा है बी को मर्डर करने का, राइट? सो ओवर द फोन आई हियर अ कॉन्वर्सेशन ए इज हैविंग विद सम पर्सन, एंड ओवर द फोन ए बोल रहा है कि भाई इस डेट को मैं बी का मर्डर करने वाला हूँ. नाउ दिस विल बिकम डायरेक्ट ओरल एविडेंस ऑन व्हाट आई हैव हर्ड. ठीक, तो डायरेक्ट एविडेंस ओरल होगा, मतलब आपने किसी भी तरह से, चाहे आपने अगर जो देखा है उस देखने के लिए आपका डायरेक्ट एविडेंस होगा. वट एवर यू हर्ड, दिट कुड बी डायरेक्ट एविडेंस ऑफ दैट. इफ यू फेल्ट, even evidence act talks about senses. So even if you felt something, so you could give direct evidence of what you have felt, so long as you were the one who had directly been witness of that. Okay, so that is going to be your direct evidence. Hearsay nahi chalega. किसी और के थ्रू कि भाई एक्स बोल रहा है कि मैंने ए को सुना था फोन पे बात करते हुए, तो वो हियरसे हो जाएगा. दैट इज नॉट गोइंग टू बी कंसिडर्ड एज एविडेंस. अच्छा, ये हमेशा एग्जाम में आता है कि भाई ये एक चीज है जो कि हियरसे एविडेंस का एक्सेप्शन है. व्हाट इज दैट? कैन एनीबडी टेल मी व्हाट इज एन एक्सेप्शन टू द कॉन्सेप्ट ऑफ हियरसे एविडेंस? दिस हैज कम अ लॉट ऑफ टाइम्स इन योर पास्ट ईयर क्वेश्चंस. This is again when I say कि भाई evidentiary law आती है एग्जाम में. Can anybody tell me what is the exception to the rule of hearsay evidence? कि भाई हमेशा evidence direct होना चाहिए, hearsay नहीं चलेगा. Can anybody tell me? This is something which has come in your exams a lot of times. Past year questions, even those one-liner principle वाले questions में बहुत बार आया है that such and such thing is a is an exception to the rule of hearsay evidence, that evidence has to be direct, that evidence cannot be hearsay. Anybody? If you're not doing this, if you do not know this answer, then I must pull all of you up and I must tell you कि भाई PYQ solve करो. PYQ का question है जो मैं आपसे पूछ रही हूँ, past year questions. When I write this, then everybody is going to say, oh, how could we forget? Remember dying declaration? And ये बहुत बार एग्जाम में आ चुका है कि भाई dying declaration is an exception to the rule of hearsay evidence. Now, does it ring a bell to anybody? कि भाई जो dying declaration है, अगर कोई dying declaration दे रहा है, तो वो hearsay evidence का जो rule है, उसका exception create हो जाता है. Supriya is now telling me, yes, ma'am, है ना? तो अब ये dying declaration क्या होता है कि भाई कोई मरने वाला है. Right, so just एक अब क्या बोलते हैं जो लॉ है वो भी ना थोड़ा सा ह्यूमन टच तो होता ही उसमें. सो दिस दे प्रिज्यूम कि भाई अगर कोई मरते मरते अगर कोई कुछ बोल रहा है तो फिर वो सच ही बोल रहा हो, वो झूठ क्यों बोलेगा? Like somebody is going to die, so you won't really lie, right? That's the general perception. So if it's a dying declaration, you're about to die and you're telling something to somebody, then that person, let's say, here X had seen A shoot B, okay, and X is my friend, and X is, X was also there when the shootout happened, and A had shot B, and then X had seen कि भाई A B को shoot कर रहा है और X भागने की कोशिश में उसने अपनी, maybe he was on a very high floor and भागते भागते वो बल्दी सी second floor से नीचे jump मार दी, thinking कि second floor ये बच जाऊंगा, but he actually landed up in the hospital and he's on the deathbed now, right? Now here this fellow who's on the deathbed, I am his dear friend और मैं बात कर रही हूँ उससे, तो मुझे उसने बताया that I saw A shooting B. So what is this? This is a dying declaration. Now here, normally, can I go to the court and appear as a witness? No, right? I cannot go to the court and appear as witness, because if I go to the court and appear as witness, it would come under the category of, किस category में आएगा? If in this whole scenario, X had seen, he's told me, and I'm appearing as witness, then it would be considered as hearsay, right? It's going to be considered as hearsay. So here, this is the exception wherein we say that even though otherwise वो hearsay में cover होता, my evidence would not have been valid, but now since it was a dying declaration made by X thereafter died, or maybe he did not really die, he was on the verge of dying, okay, but here my evidence which is brought before the court would be considered as a valid evidence. Now this is where it is an exception to the rule of hearsay evidence. क्योंकि ये मेरा testimony जो है, मेरा जो evidence है, वो direct नहीं है, वो indirect है. But क्योंकि वो dying declaration था, therefore it is going to be considered as an exception to the rule of hearsay evidence. ठीक है? Kaushal is saying, is only dying declaration the only exception? See, there are certain other exceptions. You have your section 32 जो की बात करता है और exceptions की, but the important one which is come in your exam a lot is dying declaration. Rest of them become a little more technical, so I'm not getting into them. But if you are keen, then you can look at section 32 of the Indian Evidence Act. That gives you the some of other instances जहाँ पे जो है आपका instead of direct evidence, hearsay evidence may be permitted. Okay, but dying declaration is one of the major, most important ones from there. Okay. Sarthak, yes, but then we all believe in human good, so that is why, even though it's a little more presumptuous, but that's something which, because once this person is dead, his evidence is completely like, then if let's say that's the only way to prove the guilt of the other person, then we don't have any other evidence left, right? So that's the only thing. Okay, chalo. So this was oral evidence. Now next is when you talk about documentary evidence. अब documentary evidence क्या होता है? Documentary evidence is when you are talking about in any form of document, right? Or it could even be electronic evidence, right? So electronic evidence is also considered as a documentary evidence and that is admissible. Important क्या होता है? Documentary evidence must be proved by a document only, right? Documentary evidence आप orally prove नहीं कर सकते. It's something like, let's say if you are asked to prove your date of birth, तो अब डेट ऑफ बर्थ जो है वो डॉक्यूमेंट्री एविडेंस से ही प्रूव होगा, वो ओरल एविडेंस से प्रूव नहीं होगा. So if I say that you have to prove a documentary evidence of your date of birth, then can you prove it by oral evidence? No. You will have to prove it by a document only, which means कि आप भाई अपना बर्थ सर्टिफिकेट लेकर आओ, right? या फिर आप अपना हॉस्पिटल का कोई सर्टिफिकेट लेकर आओ where you were born. So any of those things would be the document by which you can prove it. This could be primary, this could be secondary also. Primary generally means the original document. तो जो आपका original birth certificate है, that is going to be your primary evidence. Secondary evidence is normally a certified copy, right? So या फिर कोई ऐसी copy जो कि tamper nahi hui hai, which is like proved to be a genuine copy or something like that, then it is going to be secondary evidence. Okay, so there are various kinds की भाई 1 2 3 4 टाइप के उसमें आपके इंडियन एविडेंस एक्ट में कोई 8-10 टाइप के सेकेंडरी एविडेंस दिए हुए कि ये सारे जो होते हैं सेकेंडरी एविडेंस हो सकते हैं. सो इफ इट्स अ फोटोग्राफ, if you can prove with that original being there and the photograph being there कि भाई कोई उनमें difference nahi hai, then sometimes even that could be secondary evidence. Or if it's a certified copy of any document, then that could be a secondary evidence, right? So basically primary is the original, and this in certain cases law allows for secondary evidence also. So जो allowed वाली category में वो secondary evidence होगा. But basic idea is कि जहाँ documentary evidence लाना है आपको document देना पड़ेगा, either in the primary form or in the secondary form, any of these forms, but you will have to produce the document for it to be a documentary evidence. ठीक, ये आपके दो बेसिक टाइप के एविडेंस है जो कि एक्ट में दिए हुए हैं. देन अपार्ट फ्रॉम दीज टू, द एक्ट आल्सो टॉक्स अबाउट द कॉन्सेप्ट ऑफ अ रियल एविडेंस. अब रियल एविडेंस इज समथिंग लाइक ऑलमोस्ट लाइक व्हाट थिंग स्पीक्स फॉर इटसेल्फ टाइप सिनेरियो है यहाँ पे. बिकॉज अब ये क्या होता है कि मान लो ए ने, हमने बोला ए ने बी का मर्डर करा है, ठीक. अब ए ने बी का मर्डर कैसे किया? somebody had told me कि भाई शूट करा है, राइट? तो जब उसने एक्स ने ए को देखा बी को शूट करते हुए, तो वो हो गया ओरल एविडेंस कि उसने देखा, उसने ओरल टेस्टिमनी दे दी. अगर मान लो पुलिस को वो गन मिलती है, राइट, द गन विच ए हैड यूज्ड टू शूट बी. नाउ टेल मी व्हाट विल दिस, कैन दिस गन बी ब्रॉट एज एविडेंस? Can this gun be brought as evidence in the court? Yes or no? ये जो गन है जिससे A ने B को शूट करा है, can this gun be brought as evidence? Yes, of course, it can be brought as evidence. And when you bringing this gun as evidence, क्या ये oral evidence है? नहीं, this is not oral evidence. Is this documentary evidence? No, this is not documentary evidence, but it for sure is evidence. It falls within the category of real evidence. तो ये real evidence के नाम से जाना जाता है within the act itself. So any kind of physical evidence जो है, चाहे वो gun हो या चाकू हो या in some cases it could be the blood splattered clothes of the killer, like A ने B को point blank range पे shoot करा and there's like blood which is all over his white clothes. So all those clothes would also become real evidence, right? So all those things are considered as real evidence, right? So उस नॉर्मली इसलिए जो क्राइम सीन में जो सारी चीजें हो रही होती है वो क्या होती है? रियल एविडेंस, राइट? सो क्राइम सीन में जो आपको सॉइल्ड खून वाला जूता मिला, सो ऑल दैट स्प्लैटरिंग ऑन द वॉल, ऑल दैट इज गोइंग टू बी अ रियल एविडेंस. ओके, यस सार्थक, सो ऑल दैट इज गोइंग टू बी रियल एविडेंस. उसके बाद फोर्थ कैटेगरी आपकी आती है एविडेंस की, सर्कमस्टांशियल एविडेंस. ना सर्कमस्टांशियल एविडेंस is evidence which is not, directly proving the fact in issue or the relevant fact, but it is kind of an evidence जो कि आपको पता है कि भाई अगर ये, if everything is, if this has happened, then most likely fact in issue prove हो जाएगा. That's something which can help you. That is going to be a circumstantial evidence. It's something like when you talk of circumstantial evidence, it's something like, let's say, there is a case in which we are saying that A has shot B. वही केस लेके चल रहे हैं हम, स्टार्टिंग से एंड तक हम शूटिंग ही करते रहेंगे, बी को बेचारे को मार के दम लेंगे हम आज. सो लेट्स से A has shot B. Now when A has shot B here, X heard the shot. ठीक है, तो X heard the shot. तो इसमें क्या है, डायरेक्ट एविडेंस हो सकता है, ऑन ओरल एविडेंस हो सकता है कि भाई आप X को लेके आओ कोर्ट में एंड बोलो कि डिड यू हियर अ शॉट? Yes, he heard the shot. Now let's see, he heard the shot and he ran to the place जहां पे ये शूटिंग हुई थी, and there he sees A holding the gun, right? यहाँ पे नीचे B is lying on the floor dead and A is holding the gun in his hand. वो एकदम वो पिक्चर टाइप ना, स्मोकिंग गन, अभी बारूद का धुआं निकल रहा है गन से, so that smoking gun is there, and X sees A like that. Now he hasn't seen A shooting B, but he has heard the shot and he's now at the scene holding the scene A holding the gun. Now, would it mean that A has shot B? Can this be used as a direct evidence to say that A has shot B, to prove that A has shot B? क्या ये direct evidence हो सकता है to prove the fact in issue that A has shot B? No, right? Why? Because अब यहाँ पे जो A है, he could have been shooting the guy who was, maybe who had killed B, और उसको वो shoot करने के लिए उसने he might have shot the gun, and B तो पहले से ही मरा हुआ वहाँ पे, you never know. Or it could be, it could be any other thing. Maybe somebody who had shot B had just thrown the gun, and this poor fellow in confusion A had picked up the gun. So it could be anything, right? It is not a direct evidence to prove that A is the one who has shot B. But will it help you in proving that A has shot B? Will it help the prosecution to prove that A has shot B? If there are other evidences around, this could also help the case, though it is not going to directly prove, but it is going to help the prosecution in proving if there are other things also surrounding. Right? So therefore, such an evidence is known as circumstantial evidence. Right? So circumstantial evidence is also admissible, but only on the basis of circumstantial evidence, generally a person is not held guilty. Right? तो वो fact को prove करने के लिए सिर्फ circumstantial evidence के हिसाब से you can't really prove a fact, but it can help if there are other things also, other type of evidence also. Circumstantial evidence can help in proving, but it cannot be the only thing which will hold the person liable or not liable or prove or disprove a particular fact. ठीक, तो ये हो गए आपके 4 टाइप के एविडेंस. ओरल हो गया, डॉक्यूमेंट्री, रियल एंड सर्कमस्टेंशियल. I hope everybody is clear with all of them. So far, so good. ठीक है, चलो. Then let's move on. Now, next, what is important in the Indian Evidence Act is the, we decide that, okay, all these can be evidences which are admissible, not admissible. उसके बाद next stage क्या आती है कि भाई ये witness जो है, how do you examine the witness, or how is the evidence brought about, right? The documentary and documentary evidence is separate, but when you talk of oral evidence normally it is done through witnesses. So when you look at witnesses these are the 3 basic examination which happens. First is your examination in chief. Examination in chief is basically by the party who has called the witness, right? So if I am saying that, to support my case, the witness I bring, मान लो मेरे अगेंस्ट मर्डर ट्रायल चल रहा है, तो मैं अपना एलिबाई लेकर आती हूँ कहीं से, या मैं अपनी जो मेरी स्टोरी मैंने क्रिएट करी है अपने आप को प्रोटेक्ट करने के लिए जब मैं विटनेस लेके आऊंगी, द फर्स्ट अपॉर्चुनिटी वुड बी गिवन टू मी टू एग्जामिन माई ओन विटनेस. And when I'm examining my own witness, it is known as examination in chief, right? So सबसे पहला मेरा right होगा examine करने का. Then the other right is with the opposite party, the adverse party. The other party now has the right to examine, and that is going to be known as क्रॉस एग्जामिनेशन. ये तो सबसे ज्यादा कॉमनली यूज टर्म है कि भाई क्रॉस एग्जामिनेशन क्यों कर रहे हो मेरा इतना, राइट? सो व्हेन यू आर टॉकिंग अबाउट क्रॉस एग्जामिनेशन, दिस इज ऑलवेज गोइंग टू बी द एग्जामिनेशन ऑफ द अदर पार्टीज विटनेस, राइट? सो यू हैव एग्जामिनेशन इन चीफ, क्रॉस एग्जामिनेशन, और उसके बाद दोबारा से एक री एग्जामिनेशन होता है विच इज सब्सिक्वेंट टू द क्रॉस एग्जामिनेशन. तो अगर मान लो आपके विटनेस ने क्रॉस एग्जामिनेशन में आपका केस जो है वो हिला दिया, जैसे हिंदी पिक्चर में होता है ना कि अपने टिल द टाइम इट वाज योर ओन विटनेस, ही वाज वेरी नाइस एंड ही वाज वेरी बिलीवेबल, एंड ऑल ऑफ सडन क्रॉस एग्जामिनेशन के बाद उसकी जो बिलीवेबल वाला जो उसका फैक्टर है दैट हैज कम डाउन अ लिटिल, राइट? सो इन ऑर्डर टू help your case back, you are allowed a re-examination, right? So re-examination is done by the party who has brought the witness, right? So this is fairly simple. Examination in chief, then there is the cross-examination, and then you have the re-examination, right? So you have the three types of examination of a witness. ठीक? अब इसके अलावा the last thing which I want to do so far as the evidence law is concerned, there's certain basic concepts जो कई बार एग्जाम में आते हैं, so you should have an idea about it. Now, the first important concept here is when you look at the concept of that when you look at evidence law क्या ये lex loci होती है या lex fori होता है? Lex loci means law of the place, that जहां पे आपने जहां से आपको सब्सटैंटिव राइट मिला है. मान लो जहां पे वेयर देयर इज अ ब्रीच ऑफ कॉन्ट्रैक्ट, तो कॉन्ट्रैक्ट लॉ कहाँ का लगेगा? और इफ इट्स अ क्राइम, then if there is a theft which has happened, then what is the law which is going to be used? So when you look at a particular law to be lex loci, it means that wherever the wrong has taken place, the law of that particular place is going to be used. On the other hand, when you look at lex fori is wherever the trial is taking place. Case kahan pe ho raha hai? So, which law will, let's say the murder happened in France. ठीक है, तो फ्रांस में मर्डर हुआ है बट ट्रायल उसका इंडिया में चल रहा है. ठीक, सो अब लेक्स लोकाई एंड लेक्स फोराई वाला बात होता है कि लेक्स लोकाई वुड मीन देखिए फ्रांस का लॉ लगेगा so far as the trial is concerned, या इंडिया का लॉ लगेगा so far as the evidence act is concerned. So evidence act says that it is law of forum. So if the trial is going on in India, it is going to the Indian Evidence Act which is going to be governed. So that's why we say that Indian Evidence Act is supposed to be law of the forum or the lex fori. It is not lex loci. That's the opposite. So if the trial is happening in India, then it is going to be the Indian Evidence Act which will be used and not any other evidence act. That's a law of forum. ठीक. अच्छा, एक और कॉन्सेप्ट इसमें कई बार आता है, that is of relevancy and admissibility. अब ये दो चीजें बहुत क्लोज होती हैं and sometimes they are used interchangeably also. But what these two basically means is when we talk of relevancy is what we've been talking of, that a fact is relevant or it is not relevant. So a fact which is relevant, is it important that every fact which is relevant will be admitted, would be admissible, would be admitted as evidence, would be used to prove the case against the other person? Here, what law says is that relevant जो है वो, when you talk of relevancy could be of two types. Relevancy could be logical relevancy, कि भाई logically तो लगता है कि ये relevant है, and relevancy could be legal relevancy, कि भाई law इसको relevant मानती है या नहीं मानती है. Like, let's say this is something which all of you must have heard, all of you must have come across in the questions that you've solved, कि भाई जो confession होता है, if it is before a police officer, tell me, can that be treated as evidence? Confession before a police officer, कि मैंने police officer confess कर दिया कि yes, I murdered B, then can that be used in order to hold me guilty? Everybody knows it is not admissible, right? Everybody is saying no, no, no. अब logically देखा जाए तो क्या ये relevant नहीं है कि मान लो मैंने पुलिस में जाके सरेंडर करा एंड मैंने जाके बोला पुलिस ऑफिसर को कि बॉस आई एम सरेंडरिंग, पुलिस ने मुझे नहीं पकड़ा, मैंने सरेंडर करा खुद जाके पुलिस में, एंड मैंने जाके सरेंडर करा और मैं बोला कि यार यस आई मर्डर्ड बी, आई एम रियली टायर्ड ऑफ रनिंग अराउंड, प्लीज टेक मी टू ट्रायल. बट बाय द टाइम आई रीच दी ट्रायल, वहां पे जब तक मैं जज के पास पहुंची तब तक मैं फ्रेश हो गई हूँ एंड आई एम रिफ्रेश्ड, नाउ आई डोंट वांट टू अग्री टू द फैक्ट दैट आई मर्डर्ड बी. लॉजिकली थिंकिंग इट फील्स एज दो ये गलत है, राइट? तो लॉजिकली इट माइट बी रेलिवेंट बट लीगली इट इज नॉट रेलिवेंट. ठीक है. एडमिसिबल क्या होता है? एडमिसिबल होता है जो कि लीगली रेलिवेंट हो. समथिंग विच इज लीगली रेलिवेंट इज व्हाट इज नोन एज एडमिसिबल. तो कौन सी चीज एज एविडेंस एडमिसिबल है अंडर लॉ? समथिंग विच इज लीगली relevant. जो चीज legally relevant नहीं है, it might look logically relevant to you, but it will not be considered as evidence in order to prove the case. ठीक, तो evidence कौन सा होगा? सिर्फ legally relevant. ठीक, तो कई बार ये concept होता है relevancy and admissibility का. I hope this is clear. ठीक, okay, चलो. अब next आता है confession and admission. This is something which is often tested. This is something which you might have come across in some of your questions when you are solving. अब confession is always regarding the fact in issue, right? जो actual charge है, आप बोलते हो ना कि मतलब you've been charged with a particular offense. So the guy who has committed, or the guy who is actually saying that I have committed the murder or I have committed the theft. So the person who has been charged with the offense, or the person who confesses to the actual commission of the wrong, of the offense, that is what is confession. So confession is admitting the commission of that particular wrong, whereas admission on the other hand is wider. Admission is to a fact. Admission could be to a particular fact, which is, a fact in issue या relevant fact. Because evidence है, तो evidence उसी चीज का हो सकता है जो fact in issue है या relevant fact है. तो जो fact in issue या relevant fact का admission हो रहा है, कोई भी और कर रहा है. But for the person जो actually बोल रहा है कि I have committed the wrong, right? So here, when a confession is exactly agreeing to a particular wrong that you've done, that I have murdered somebody, that is going to be a confession, whereas an admission is much wider. Admission जो हो सकता है वो किसी भी और चीज के लिए हो सकता है. ठीक, तो कई बार एग्जाम में आपके ये क्वेश्चन आता है बिटवीन कन्फेशन एंड एडमिशन. सो एक ब्रॉड चीज याद रखना, एडमिशन किसी भी फैक्ट का है. आपने एग्री करा कि यस आपने let's say that I sold the murder weapon to A, right? A killed B, and if A says that I killed B, that will be a confession. But if X says that he sold the murder weapon to A, then that is going to be an admission, because ये एक बहुत ही important relevant fact है, और ये relevant fact का क्या है? ये admission हो रहा है, right? So when you are talking about admission, admission could be any fact which is relevant, उसको आप yes बोल रहे हो, and confession हो जाएगा कि भाई जो आपको offense charge करा है आप उसी को admit कर रहे हो, उसी को आप बोल रहे हो कि yes I have committed it. That is what is a confession. So therefore confession and admission are two different things. Is this clear? Confession and admission समझ में आया? I know थोड़ा सा complex है, but इतना difficult भी नहीं है. I'm hoping I'm not going from sides and up and everywhere. It is actually going inside where I'm aiming for. Yes? चलो ठीक है, तो ये हो गया कन्फेशन, ये हो गया एडमिशन। अब लास्ट टॉपिक है आपका एस्टॉपल। एस्टॉपल जो होता है उसका मतलब it is something, very close to what we had done when we were doing contracts. Everybody remembers the concept of estoppel when we were doing contracts, or when we were doing torts, when you were doing vicarious liability. So that is the time we had spoken of estoppel. When we were doing contract consideration karte time bhi aapne estoppel padha hai. Can anybody tell me what do you mean by the term estoppel? ये एस्टॉपल वर्ड आप लोगों ने पढ़ा है जब हम कंसिडरेशन पढ़ रहे थे कॉन्ट्रैक्ट में। ये एस्टॉपल, गुड सुप्रिया, लाइक प्रोमिसरी एस्टॉपल, यस। एंड आपने एस्टॉपल तब भी पढ़ा है जब हम पार्टनरशिप पढ़ रहे थे वाइकेरियस लाइबिलिटी के टाइम। यू मस्ट हैव कम अक्रॉस द टर्म एस्टॉपल देयर आल्सो, right? Okay. Supriya is telling me promissory estoppel when on a promise somebody does something, right? So estoppel का वहां पे भी मतलब था that you stop from going back. एक बार आपने कुछ प्रॉमिस कर दिया तो आप उस you cannot go back on that, right? And जब आप promissory estoppel पार्टनरशिप के कॉन्सेप्ट में देखते हो तो वहां पे भी पार्टनरशिप बाय estoppel होता है that if you kind of acted in front of everybody that this guy is my partner, फिर अगर कोई लाइबिलिटी क्रिएट हो जाती है then you can't say that no I am not a partner. Why? Because through your actions you've acted as though you were a partner. So again you stopped from going back. So estoppel in law always means stop from going back. So that is why when you're talking about law of estoppel in evidence also, it means that if once you've said something, you cannot in evidence go back on that. इसके ऊपर 2021 में AILET में एक क्वेश्चन आया था on the concept of estoppel. In fact, जो evidence law में there is a particular section which talks very specifically, वो उन्होंने सारा का सारा वो section ही उठा के 2021 के AILET पेपर में डाला था. And that concept was that if there is a tenant and if when you are taking a house on rent, and at that point in time, you have not questioned the title of your landlord. Thereafter, later on, you cannot question the title of your landlord, right? Once at the time, let's say आपने 2000 में you had taken a house on rent. आपने 5 साल के लिए rent पे लिया था. 2003 में, जैसे कि ये question में भी था आपके AILET वाले, 2003 में there is another person who comes and says that no. Your landlord is not the true owner. I am the true owner. So give the rent to me. And you start giving the rent to the new person. So the initial landlord, he filed a case against the tenant claiming कि भाई आप मुझे rent नहीं दे रहे हो, आप किसको rent दे रहे हो? He wants to claim the rent. Can this person, the tenant, say that no, I'm giving rent to somebody else, hence I'm not liable to pay the rent to the initial landlord? Can the tenant get away from his liability to pay rent to the landlord? No. These are the exact facts of the question which came in AILET. और ये क्या है? Estoppel. Where you are stopped from going back on something which you had admitted earlier. तो जब आपने 2000 में घर किराए पे लिया था, उस टाइम आपने admit करा था that he is the owner of that property. So at a later date, you cannot refuse that now I don't believe you are the owner of the property. Why? Because in 2000 you had admitted to that. So that's exactly what estoppel is. Estoppel is that once you've admitted to a fact, then at a later date, you cannot, even give evidence against it. Or you cannot give evidence opposite to what you had admitted once. Take? That's the concept of estoppel. And this is how it had come in your AILET paper in 2021. Anybody remember this question? याद है ये question किसी को? Yes or no? अगर ये question याद नहीं है, boss, past year question papers लगाइए. PYQs very, 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 very important. Okay? Now again, ठीक है? चलो then. I think this is where we come to an end so far as your class on evidence law is concerned. These are all the major topics which you need to be aware of. इससे ज़्यादा evidence act में बहुत ज़्यादा घुसने की ज़रूरत नहीं है. These are the basic things which are important for you guys. These are the certain important concepts जो कि आपके exams में आ सकते हैं. ठीक? चलो. Take care everybody, and this is your last session on miscellaneous laws, procedural law. Miscellaneous law का last session नहीं है, but procedural law का ये last session है आपका. ठीक. Next we will do something fresh, something new. Procedural law हमारा अब खत्म हो गया है. ठीक. And for those of you who are new, who are watching this video for the first time, we do have these kind of sessions on other procedural laws also. So if you feel the need that you need, this has been helpful, do let us know in the chat box. And thank you so much. Okay. Thank you, Hasika, Sindhuja, Chahat, Supriya, Abhinav. Thank you so much for you guys for being here. And it was lovely to have you. Okay? चलो, टेक केयर, स्टडी हार्ड, और भाई तुम लोग सब PYQ लगाओ, बहुत जरूरी है, बहुत इंपॉर्टेंट है. ठीक, चलो, टेक केयर एवरीबॉडी, हैव अ ग्रेट वीकेंड अहेड एंड सी यू अराउंड. थैंक यू. बाय बाय.